Hand-down judgment in the matter of NA, Bangladesh and others and Secretary of State and Home Department.
For the reasons given in the judgments I now hand down, this appeal is dismissed.
Hand-down judgment in the matter of the Independent Works Union of Great Britain, IGWB, and the Central Arbitration Committee, CAS.
For the reasons given in the judgments we now hand down, I now hand down, the appellant's appeal is dismissed. Permission to appeal to the Supreme Court is refused, and the appellant will pay the costs of the interested party on the standard basis, subject to the cap ordered by Lord Justice Mayles.
The other in the matter of Mr Rix and the Paramount Shopfitting Company Ltd.
Yes.
Yes, Mr. Cavanagh.
Please, your Lordship and my lady, I appear on behalf of the appellant, the defendant below, and my own friend, Mr Rix. Queen's Counsel, as before, appears on behalf of the claimant respondent. My Lord and my lady, the bundles consist of a core bundle and a supplementary bundle. I have a horrible feeling that my references to the core bundle may be inaccurate, though I don't need
I didn't. If they are, I didn't notice them. It's not a complicated bundle. We found our way around. At least speaking for myself,
I think the supplementary bundle references are correct.
But we're not going to need to look at the supplementary bundle, are we?
Your Lordship will need to.
Oh, right. Okay.
I hope.
Perhaps we will on grounds. Oh, it doesn't matter. Keep going.
Ground one.
Well, if we have to go to it, that's fine.
Yes. I'll take it as economically as I reasonably can, but there are some references I need to make.
Yes, of course. No. Well, I'm bound to say, speaking for myself, though I'm sure not for my lord and my lady, I have focused in my pre-reading largely on ground one.
Yes. It is under ground one that I need to take the court to some of the references.
Oh, well, there we are. Okay.
Lord, lady, we've lodged an amended skeleton argument. That came about because...
yes, we saw, because of the head.
Head and Culver.
The head case.
What happened was that after Head and Culver had been handed down in January this year by the Court of Appeal, Lord Justice Bean directed that we amend, if so advised, to take account of that judgment. And
yes, perhaps you can just help me on this. There was an oral hearing.
There was.
But that's unusual these days. They're not, of course, unprecedented. What were the circumstances? Was that because of?
I believe so. We weren't told why, but we were simply directed that it would be heard in court. And my learned friend attended, as it were, virtually.
Yes.
And I attended in person.
I see. Well, I suspect that is the reason. But if Lord Justice Bean gave any substantive reasons or made any substantive observations, we don't have a transcript of them.
No, he didn't do anything more than say he gave leave. To be fair, he said with some misgivings. I ought to say that. I don't think he said anything more than that, but we had about an hour or so of debate before him.
Yes.
About the grounds.
And perhaps I can, just while we're looking at his order, he asked for a respondent's notice, not asked for, sorry, gave a time limit for one, if so advised.
Yes.
We haven't got one, although I think it's implicit in your skeleton argument that you are hinting you think there ought to have been one, but we'll cross that bridge when we come to it.
Well, there are two separate points. I think respondent's notice was specifically about what my learned friend called, or the judge called, basis 2.
Yes, quite.
Calculation. From recollection, Lord Justice Bean was talking about a revised a response to it, but my own friend put in their respondent's skeleton argument, I think, after, as is normal, after...
yes, of course, no, but it does say respondent's notice if so advised.
Yes.
That was my point.
Yes,
and I just wanted to check.
No,
there isn't one.
There is none.
No, okay.
Lord, this is a case where, under the Fatal Accidents
Just
Act,
before you get underway,
yes.
I mean, we have obviously... I have now revealed that I haven't read the papers as fully on grounds 2 and 3 as I have on ground 1, but we have all read the papers.
Yes.
Do you have a feel for how long you're likely to be?
Well, I'll certainly finish by the midday adjournment, but it may not be much before then.
Okay. Well, that's
I hope
good.
it will leave enough
No,
time
I'm sure it will.
My lords and my lady, Mr Rix died on the 20th of April 2016, just a month before his 61st birthday, sadly, of mesothelioma. Liability had been admitted, and the claim was on behalf of his widow, Mrs Rix, as his dependent. Mr Justice Cavanagh was concerned only with the issue of the financial dependency for various reasons, because there were some medical issues that couldn't conveniently then be tried and remain outstanding as to Mr Rix's life expectancy, but for the asbestos.
Is Mrs Rix in court?
Yes. Thank you for I should have asked myself whether that's right. He suffered from type 1 diabetes. So that issue went off, and as a result, the learned judge gave judgment on annual net losses, which would then be factored into any further findings as to life expectancy and multipliers. And his findings as to those are in paragraph 106 of the judgment, and they go from about £75,000 a year in the early period, reducing because of the way in which state pensions come in, to about £64,000 a year net. Lord Justice Bean gave leave on 3 grounds. In summary, the defendant's complaint is that the annual figures taken by the judge far exceed any loss which could even, on a broad brush basis and a jury award basis, have been sustained by the claimant in the 4 years before trial, or since the death of her husband, or will, on the balance of probabilities, be sustained in the future. And this is not, we emphasise, because of structural aspects of the Fatal Accidents Act, which undoubtedly do involve, in certain circumstances, awards which exceed actual losses, in particular Section 4, which requires the disregard of certain benefits accruing from the deceased himself. As the judge said in paragraph 30, the principal battleground between the parties in the present case is Section 3, not Section 4 of the FAA. Pursuant to Section 3, a dependent claimant can only recover damages if she or he has suffered financial injury as resulting from the death. It was expressly on the basis that the subsequent performance of the company, in which the claimant and her husband had an 80% shareholding between them, which formed the bulk of the household income prior to his death, it was expressly on the basis that was irrelevant to the calculation of the financial dependency. My Lord, the primary facts were not in dispute, but they are important. Over 4 decades since he had started and grown a business from scratch at the age of 21, a reasonably substantial concern with established commercial customers and workforce was in place. History and nature of the business is set out in paragraphs 12 to 26 of the judgment, and one sees also in paragraph 25 the turnover and gross profit of the company after Mr Rix ceased to be involved in its management. In fact, the first year he stood down effectively in December 2015, so in that accounting year he was no longer at the helm for about 6 months.
And Mr Ken, can I take it that of those facts that are set out in paragraphs 12 to 26, no issue is taken?
Yes, there was nothing, really none of the primary facts were in dispute. Though I may need to supplement them slightly just to make good points I'm going to make. Nothing I say in this appeal is intended to devalue in any way the achievements, considerable achievements of Mr Rix in setting up his business and growing it to the point which it had arrived at in 2015-16. Or indeed to suggest that he did not remain, up to the time he ceased to be involved in its management in December 2015, a very important and indeed central factor in the business. Our point is this, that it was the very fact of his successful efforts over the years that when he fell ill, he had managed to establish, as was always intended, a business that had continued viability even without him, and which would, again, as was always intended, be handed over to his sons as again has occurred, sadly, at an accelerated pace. And we say the judge fell into error in treating the undoubted fact.
Just give me one moment, sir.
Sorry.
Yes, do carry on, yeah.
We say the judge fell into error in treating this undoubted fact that I've just acknowledged about Mr Rix, that he was central to the development of the business and remained important to it, as meaning that come what may, all the future profits of the business, in effect, continued to be completely reliant upon his continued presence at the helm. When self-evidently, we say, the business was a going concern that has continued to trade on much the same basis and to produce profits. Something we say is unsurprising because Mr Rix's efforts over the years had paid off. He had been office-based since 1994, and the work was done. The work of the business was delivered by a workforce and subcontractors. And we say that the learned judge fell into two errors, broadly on the basis of two errors of law. Firstly, by a misunderstanding as to what is meant by dicta in various authorities, to the effect that the dependency is fixed at the date of death, and that nothing that anyone does thereafter can either increase or decrease it. And secondly, we say by ignoring the fundamental feature of a trilogy of authorities, all of them perhaps surprisingly because they're regularly relied upon, unreported, although one of them, Wood and Bentel Simplex, is in fact in the PIQRs, and I've put that report had that put on the bench. The trilogy of cases, Wood and Bentel Simplex, Cavanagh J, and Williams and Welsh Ambulance, in which it was expressly recognised that in a family business of this sort, it is not the correct approach simply to treat all the profits of the business that would have accrued to the deceased had he lived as the starting point for the loss of financial dependency.
Certainly as regards the second error of law, if you succeed in showing he fell into that error, it would nevertheless follow, wouldn't it, that you would be liable on basis 2, though there would obviously be an argument, not for us, as to what the quantum would be.
Yes.
No doubt you would say whatever it would be lower than the quantum that the judge ordered, but...
Yes. Lord, what I can show you in a moment, what we said at the in the counter schedule before Mr Justice Cavanagh was that no properly formulated claim had been put forward. My learning, and therefore it wasn't for us to say how it should be done. We suggested one way might have been how is the profitability of the company impacted by the absence of Mr Rix, and that would feed through to the shareholders as a loss. My learned friend then put forward basis 2, which was the cost of a replacement manager, relying upon a supplementary report from his forensic accountant. But the learned judge said there was inadequate evidence before him. My lords, I have to say that having had the benefit of Lord Justice Bean in Head and Culver, which is a slightly different case because it's a claimant with a lost year's claim, and so the issues are not quite the same because here we're concerned with what Mrs Rix has lost. That there are clearly other ways of doing it. Lord Justice Bean, to give you, as it were, advance notice of of that case, was effectively saying you can put a value on the founder manager's continued work. That's probably the same as what was happening in Williams and Welsh Ambulance.
Yes, that is basis 2, isn't it?
Well, it is. The problem with basis 2, and there is a point of principle between the parties, was that my learned friend said, take the cost of replacing Mr Rix, and that is your loss. The only credit he was prepared to give in relation to continued earnings from the business, continued earnings on the part of Mrs Rix was the.
Well, that's okay, but that's a separate point. What I was just trying to find out was that if you're right with your second point of law, maybe even with your first, but let's stick to the second, which is more obvious, namely ignoring effectively the trilogy of cases to which you refer. If you're right about that, it doesn't mean that you escape liability scot-free.
No.
You just get, sorry, you just take,
award.
it doesn't mean there's no loss, it means there's loss on a different basis.
Yes, it makes, I will say that there are points of distinction, which mean you can't simply, you can't simply mechanically apply that methodology to this case.
Well, I'm happy to accept that, but I'm just trying to look at the big picture, because it was clear to me that formally, looking at your appellant's notice, what you're basically arguing for is simply no dependency at all. But that seemed to me, especially when I got into the weeds of the argument, a slightly unrealistic position.
Well, and
that realistically your position is no dependency on the basis the judge found.
Yes.
But subject to your point about it not having been properly advanced or pleaded and all the rest of it, the logic of winning on the arguments you advance is there will be dependency on basis, there will be a loss to be calculated by reference to basis 2.
We don't go so far as to concede there will be a loss for the reason that your Lordship's familiar with the Coward and Comex calculation that is done at the end of as part
If
of
I said there will in principle be
yes.
a loss.
There might be a gross loss,
yes,
and then there is a question of what the net loss will be, and we don't know. And there are cases, and it's often, for example, Mr. Jonathan Adams, who gave evidence, I don't know whether he's in court, but he gave evidence, and he's taken over as managing director, said that he and his mother are very upset with the notion that there could be no loss, and we understand what he says. We entirely understand that. But it is a function of the calculation which is adopted in these cases, that because you take off the saved living expenses, you can have a case where there is a loss in the sense that there's a gross loss of income coming into the family budget, but the dependent isn't in fact financially worse off. So that's the only caveat I make to that.
Yes, very well, but you accept that at least on one aspect of your argument, if not on both, you don't escape scot-free. There is a dependency in principle, subject to your point about then netting off.
Yes,
yeah.
And in fact, at the end of my submissions on ground 1, I was going to submit various ways in which it might be done. It isn't simple.
Okay, well, that's very helpful. I didn't want to take you out of your course, but I just really wanted to get this clear in my own mind.
And I should say about basis 2, what my learned friend says, although he hasn't put in a respondent's notice, we don't want to put it, take any technical points. He, as we do, suggests that if ground 1 is allowed, then the matter could be remitted.
Yes.
And so that basis 2 would then become available, or any other basis, of course.
Yes.
Is a proper.
Yeah, well, so that's common ground.
Well, it's what we say in our skeleton.
Yeah,
and
that's fine.
My own friend in his skeleton.
Yes, no, exactly.
Ends up in that way, really.
Yes.
So we do say an alternative is for this court to make its own calculation, but that's the problem with that is that there isn't really the material.
There isn't.
Before the court. So returning to what I say about this, so what those cases show is that, as I've said, you don't look at simply the profits, and we can see from the cases that the profits in those cases were substantial, but that wasn't the approach adopted by the Court of Appeal. In summary, ground 2 is all about it's a pure point of law. It's about the reallocation, the notional reallocation of profits in relying upon authorities which are concerned with personal injury cases and informal partnerships, which we say doesn't quite work, or it doesn't work at all in the case of a shareholding in a limited company. And in any event, it arises only if we're wrong about ground 1, because for reasons I will explain. Ground 3 is we say that at the very least, surviving income from Mrs. Rix's own shareholding has to be factored in, because it's not affected by the Section 4 disregard. She, from her own shareholding, she always owned those shares. What I hope to do is set out a bit more about the primary facts, and then moving and spend most of the time on ground 1. To go straight to what we say are the errors in the judgment, if your lordships have the judgment to hand. First of all, paragraph 4. After setting he's dealing with. In the third line, Mrs Rix's primary contention as regards quantification is that her financial dependency should be calculated by reference to Mrs Rix's share of the annual income that Mr and Mrs Rix would have received from the business if he had lived, basis 1. Then he refers to the secondary. Basis 2, alternative. And then in paragraph 94, I'll obviously come back to quite a lot of the detail of the judgment in due course. We have, having set out the authorities that I've just mentioned, the judge says this: the objective, therefore, in a family business case is not to compare the income of the dependent from the family business before and then after the deceased's death, and to award the shortfall, if any. The income of the dependent from the business after the deceased's death is irrelevant. The inevitable consequence of that is that there will be cases, such as Williams itself and in the present case, in which a substantial award for financial dependency will be appropriate, even though the deceased's breadwinner's businesses continue to thrive and provide an income for the dependent or dependents even after the deceased's death. And we say that that is a misdirection and it misunderstands what was happening in Williams. Williams was not avowedly a case where the court was saying our approach, we acknowledge, gives an award which exceeds the probable loss. What the Court of Appeal was doing, as was His Honour Judge Hickinbottom, as he then was, at first instance, was finding a way of, as it were, a proxy for the loss, which is so difficult, and we accept it's difficult in family business cases. You have a man who's employed on a salary, you've got the salary as the starting point. If you have a man who has his own business, he may take a low salary for reasons of tax efficiency, and he may take some of the profits or all of the profits. And we accept the difficulty, and Lady Justice Smith in Williams faced that and acknowledged that. But if, as it must be the case, Mr Justice Cavanagh was reading that as saying that what happens thereafter is irrelevant, and that if his award exceeds actual losses, that's just a function or a consequence of the authorities. We say that's a misdirection.
So which particular sentence in 94 do you say is wrong? The second sentence?
Well, to say it's irrelevant, yes, that's the second sentence. It's irrelevant. It depends what one means by irrelevant, and we'll come to that in a moment. Because one can, if it simply means, well, if the business has done well because someone's come over to take it over, and it's gone through the roof, that's irrelevant.
If we took out that second sentence, would you have any other objection to paragraph 94?
Yes, the next sentence, the inevitable consequence, there will be cases, such as Williams, and we say it isn't Williams, it isn't the case in Williams, and in the present case, in which a substantial award will be appropriate, even though the deceased one has continued to thrive and provide an income. And, my lords, we can see the steps in his reasoning in paragraph 60. Where he sets out under 8 sub-paragraphs what he derives from the authorities. And as I say, I'll go back to the authorities, but we don't have any quarrel with the first 3 propositions. But then in 4, there's a difference between an income-producing asset, such as a rental property or an investment on the one hand, and a business which was benefiting from the labour, work and skill of the deceased on the other, where the value of an income-producing asset is unaffected by the deceased's death. There is no financial loss or injury as a result of the death, and so there's no claim under section 3. Where, however, the deceased worked in a business that benefited from his or her hard work, the dependent will have lost the value of that hard work as a result of the deceased's death, and so will have a financial dependency claim. Now, my lord, depending how one interprets that, that is either unexceptionable or it is a clue to where we say that learned judge went wrong later on.
Obviously, how can you interpret it? Isn't it obviously right? Well, and it's what Lord Justice Staunton said most clearly in Wood, isn't it?
What we say, the difficulty we'll see from the later sub-paragraphs is that he is seeming to make a distinction between, on the one hand, what one might call a passive investment, such as a property or a portfolio of shares, and on the other hand, any business in which the deceased was involved. Whereas we say, clearly there will be hybrid cases, and that's exactly what Lord Justice Staunton had in mind when he gave the example of the boarding house. And what indeed Lady Justice Smith had in mind in Williams, where she says at paragraph 51, you have to get at what is the part of the income which is generated by his work, and the part of the income which is generated by the capital.
Well, what part of 60 subparagraph 4 do you say is wrong?
Well, if read in the way I've suggested it may be read, from looking at paragraph 94, he is, as it were, only acknowledging that it's the passive investment case where you don't have a loss under section 3. He isn't acknowledging that however big a business becomes, as long as you're still in it, even if you're Bill Gates or whatever, it's you're working in it, and therefore your skill is going towards it,
Yeah.
and the loss therefore falls on the other side of the line. And we say,
What do you mean on the other side of the line?
well, on the side of the line that you get the lot, as it were.
Yeah,
the
but isn't
whole-
that right in principle?
No, my lord.
The problem is that there's then a problem. Suppose you are Bill Gates. Effectively, what the basis 2 analysis does is it says, however big the business, however much it would run itself, even if Bill Gates wasn't there, the fact is Bill Gates is the head.
Yes.
And is contributing, must be assumed to be contributing something. And the way we quantify that, not perhaps in every case, but it looks like a convention is beginning to develop, is to say, what would you pay to have someone like Bill Gates running your business? And that's
basis 2.
That's basis 2. Yes, well, this comes back to what I was exploring with you earlier. You really have no problem about basis 2 in principle.
Subject to that caveat, yes.
So what really is the problem with 4? Because speaking for myself, it seems to me to reflect the line of authority, beginning with Wood and taken through by, not least, Lady Justice Smith and 2 authorities, not least Williams, which carefully reflects and most closely reflects the facts of this case.
Well, my lady, what we say is wrong with it is what we know that the learned judge later did, which is to adopt basis 1. If he'd gone to basis 2.
No,
There's nothing wrong with 4 then, is there? There's nothing
Well,
wrong with 4.
I agree that I accept that paragraph 60, he's summarising the
Is there any other, are any other subparagraphs?
Well, then
5 onwards are wrong.
If one reads on,
you say.
paragraph 5, whether a dependent suffered loss is fixed and determined at the date of death, we'll come back to that.
But do you agree with that? As a
Yes.
statement of law?
Yes,
Right.
it's the expectation at the death. What we don't agree with is that the court can't receive evidence of what has happened since to supplement and make good what that expectation was.
And does the
That's
judge disagree? Does the judge come to a contrary view? Does
Well,
the judge say you can't receive evidence?
he does effectively. And
Will you share us that in a minute? Okay?
And then he says in 6, it follows from the fact that the loss of financial dependency is fixed at death that in a work skill case, the existence of the right to claim loss of dependency and the value of the loss is not assessed by reference to how well the business has been doing since the deceased's death. Again, that is unexceptionable if what is meant by that is that if it does better or worse than it would have done, that because you have a good manager or a bad manager taking over, that can't affect the dependency up or down. But if as he does at the end, say that what the business has done since has no relevance, then we say there is an error. And then we see this in 7. Moreover, a dependent, well, it's the same point, cannot by his or her own conduct after the death affect the value of the dependency. And then 8, therefore, even if the business is now thriving and doing better than ever, the law will treat that as having been a financial injury and so a loss of financial dependency. And I submit that while one can justify that as a general proposition, we see that learned judges attaching some significance to it, and that's why in paragraph...
If he can justify it as a general proposition, he's quite right to attach significance to it.
What I'm doing, my Lord, seeking to do is say there was misdirection of law in paragraph 94, and that this paragraph 60 provides a clue to the process of reasoning which results in that error.
I see. So 60 is all right in itself.
Well,
But let me just finish.
Right.
I'm just writing this down. You tell me if I've got it wrong. But contains a clue as to the misdirection which occurs in para 94.
Yes. And the reason I say that is that if one applies the approach adopted in Wood, Cape and Williams, then it is correct that in those cases the businesses remain profitable. But that doesn't mean to say that there isn't a loss, and if that's all that it means, that's fine. Because the business might have been more profitable, or the dependents might have the expense of replacing the deceased. There are other ways of getting at it. What the court is always trying to do, in a rough and ready way, is get a handle on what the loss, what the value of the deceased's labour and contribution was, which has been lost.
Yeah.
Can we go back to 94? I don't want to take you over this too much. You agree? Did you object to the first sentence of 94?
Well, it's again, I object to it in the way it's used by the learned judge.
Well, do you?
Because
Do you disagree with the proposition that the objective in a family business case is not to compare the income of the dependent from the business before and after death and towards the shortfall,
because
if any?
What the learned judge, we know from his award at the end, was clearly doing, was saying it's irrelevant if the business continues. If I can provide an analogy, let's say a deceased was a man of leisure and lived off a portfolio of shares. There's no loss, and that's not because you're prevented from comparing the income before and after. But if there's a combination of shareholding, investment income, work, salary, and so on, then there will be some loss. What is not right is to, and this is what was described as a perverse incentive, I think, by Judge Higginbottom, is for a defendant to gain by someone taking the reins of a business and keeping it going, or on the other hand, the claimant to lose by by it being run into the ground, even though it was a perfectly viable business.
Isn't it as simple as this? In what you call a hybrid case, which actually all these business cases are, the two extreme cases are portfolio of shares not being actively managed, you're just sitting on them, and the survivor, typically the widow, inherits the portfolio and gets the income, and clearly hasn't suffered any loss. The extreme is, the other side is a man who works, well, maybe it's a salary, but to make it a little bit closer to this, has a business where he does all the work himself. There's there's no asset apart from his own efforts. And then she's lost all the income because he generated all the income. Then you've got an in-between case where assets have been built up over the years and she inherits, or the family inherits those assets. But nevertheless, the deceased was active in the business. What the law then does is says that it will treat his activity as having a financial value which has been lost, so there is a dependency. There's then simply a question of how you value it. And while saying different cases are different, the trend that seems to be developing is that you value it by putting, as it were, a market value on those services, i.e. basis 2. If that's what you're saying, speaking for myself, but possibly not for my lord and my lady, I have a lot of sympathy with it. If you're saying that simply because the business made a lot of money more money after he left, there is no loss at all, then that seems to be plain contrary to what the authorities have said.
But what we were saying was that if this case had come to trial within months of Mr Rix's death, we would have said the forensic accountants would have pored over the financial results and would have said this is a viable business, and these shares will go on producing an income. They may say, as did the forensic accountant called by the claimant, Ms. Hardless, that she believed that there may have been a falling off of turnover, and I can take court to that. Or they may say, well, he was a central figure in the business, and therefore plucking a figure from the air, the turnover would have been 10%, 20% more, or, as your lordship indicated, basis 2, we're going to have to put someone in.
Sorry to interrupt your flow, but it is an important point. There's an inherent difficulty, problem about basis. Basis 1 at once in that sort of situation is speculative and difficult.
Yes.
Because you're trying to work out how much more the value of the business would have been, the income of the business would have been, had he still been active, which is extremely difficult to prove because there are so many factors in the viability of the success of a business, the income of the business. Whereas adopting an admittedly notional,
yes,
but comparatively straightforward approach of saying what is the market value of someone doing that person's job solves all those problems.
Well, yes, my lord. Basis 1 wasn't, of course, inviting speculation. Basis 1 was saying, and I perhaps should just take you to how it was done, because it's quite important. In paragraph...
My fault, I've taken you off your course.
No, I think this is the perfect moment to address this point.
So we get to the end of the judgment.
Well, 107 he sets out, 106 rather, the annual figures he takes, and he gives an example of working for one year, 107, July 2019 to May 2021, and these are annual figures. Annual income attributed to Mr. and Mrs. Rix's income from MRER, 108,678. Now that's a net figure taken from Miss Hardless's report after corporation tax, after income tax in the hands of Mr. and Mrs. Rix, allowing for the tax-efficient method of splitting the profits.
This is their after-tax income.
Yes, and it's not actually income because it's not based on historic figures, because a significant proportion of the profits were retained in the company. And so this is a share of the profit, 80% share of the profits, netted down after corporation tax. I should have said a slightly increased share of the profits, because she assumes a 13% higher turnover initially if Mr. Rix had remained at the helm. So she builds in an increased turnover. She then says, that's what the business yields.
Sorry, that's what the business needs.
No. This is what
I may have misheard you. What did you say?
This is what the business yields.
Yields. Right.
Yields, or rather, what the business would have yielded if Mr. Rix had remained there, which is assuming a slightly higher turnover.
So I just want to be quite clear what this figure is.
Well, I can. It's easier if I show you by reference to the accountant's report.
Well, just keep going through this for the moment.
And then the accountant took 70%, which was a cautious figure. Although they have an 80% shareholding, the accountant took 70% of the profits, because that had been the way in which the distributed profits had fallen in the past. The sons are 10% shareholders, and then. And so that works through. Then there is that's the net, as it were, the gross loss of dependency, and then you have the annual rental income from commercial property, which was conceded should come off, and then there's this current. So you add those two together. You then take the 2/3 figure for loss of dependency, comes to £88,125, and then you deduct Mrs. Rix's surviving commercial rental income.
And it says that you didn't object to the approach being taken.
Yes, well, that is with respect misleading, and I'll have to take you, one reason we've got a transcript in the bundle, I take you to one reference in the bundle to that. It may be convenient to do that now. It's in the supplementary bundle. At page 300. sorry, 289. And these were my closing submissions. That letter, starting right at the bottom, last paragraph on 289, bearing in mind that the primary point made was that there was no properly formulated claim, because we were facing under basis 1 simply all the profits of the business provided the starting point, whether or not they were lost. And so I say at H on 289, what of course is interesting is that this is well below the actual profitability. I've been referring to the dividends.
Just, sorry, you're confusing me, but you're putting in so many qualifications.
Sorry.
What is the actual point?
The point is that I was, the reference to not objecting to that approach was not objecting to the way in which the accountants were getting at what, had Mr Rix survived, would have been the benefit to him from the company.
Sorry, can you just run that one
Yes.
past again?
What had Mr Rix survived, what would have been the benefit to him and his wife of the profits of the company, either in salary, director's salary, or profits that they were entitled to a share of under their
Sorry.
shareholding?
It's not about profits, is it?
Well, that's the starting point for the...
I still haven't quite understood what one is. Have I got this right? What the judge refers to as the annual income attributed really means this, does it? It means the estimated profit of the company after tax in a particular year
It might
reduced to 70% for reasons I don't quite understand, but it doesn't matter, but you can explain in a minute. And then it is assumed, contrary to the fact, that the whole of that 70% would have been distributed to the two of them,
Yes.
or either by dividend or by salary.
Yes.
Is that right?
Yes.
So in calculating the profit, you actually wouldn't take into account the salary.
Well, the salary is taken into account because there's a tax efficiency way of doing it. Well,
Yes, quite.
I can show you in Miss Hardless's report what she did. But in summary, it is simply what would have been gained from the business, either by capital gain, if you plough back profits, you're adding to the value of the company, if you're a shareholder, or by income.
Well, that's not a helpful way of looking at it. As soon as you start talking about capital gain, that's not... The point is that the company makes this money in this year, and subject to the deduction to 70%,
Yes.
that is treated as being annual income attributed to them, whether they took it or not.
Yes, exactly.
That's all I want to do.
And in fact, I had something to say, going back to page 289, about this. What had led to that was that I was identifying the level of dividends that had been paid out, which were well below these figures.
Yeah, that doesn't matter.
And then, so I made the point. So at the foot of it, now, it's interesting, it's well below the actual profitability of the company. On any view, there was quite a lot of profit that was retained in the company. Apparent from these tables, for example, and I'll give an example. We'll see that in a moment, the retained profits. Then at B, on the next page, it raises a bit of a complication in relation to calculations and tax and so on, but for present purposes, we are not minded to object to that approach. Obviously, if somebody, for example, if this business had come to an end as a result of Mr Rix's death, we would hardly be able to say, well, Mrs Rix's loss was based upon the dividends that Mr Rix was being paid. You would have to take some account of the profits that were being ploughed back in, because there is a gain at some point, maybe a capital gain. It poses another complication. So all I was saying was that if you're looking above the line, as it were, at what would have been the benefit to the Rix household of this company, and Mr Rix continuing as its manager, then it's perfectly right to look at everything and not artificially look, for example, just at his salary, which is very low, 8,060, which is just the threshold for paying national insurance contributions, for example, or at the distributed dividends necessarily. But that's above the line. And the point I was making here was that, letter C, if the business had come to an end as a result of his death, we couldn't be arguing that the loss was only what had historically been distributed, because Mrs. Rix would have lost an entitlement, directly or indirectly, to all the profits. And so what we weren't objecting to was a calculation which was a little bit artificial, but that restated the household income, split it between Mr. and Mrs. Rix for tax efficiency purposes, and then took off tax, as would be appropriate, on the income coming in. Fundamental.
And sorry, and the obvious reason why 70% is, in fact, they had between them they had 80% of the shareholding, and then for a particular reason it's reduced to 70%. Now I'm understanding
distribution. It was generous to us in a sense, but there was that slight adjustment. And so at letter, and the other point I make at letters E to F is that if you're going to do it that way, above the line, including retained profits, then you must, below the line, seeing what has survived from the assets, you must take off retained profits as well, because just below letter F, if you're going to include retained profits, you must include it at both ends of the calculation. So that's one caveat. You've got to compare like with like. So with respect, it's not quite the same as saying that I was conceding. Certainly I wasn't, because it was quite contrary to the submissions, the point made in the counter schedule, the submissions I've been making, that it's all right to look at the whole of the profits, and that's somehow that is acceptable as getting at the, as it were, the above the line figure. Just to give you the reference, the counter schedule is the schedule of damages simply adopted Mrs. Hardless's report, so we get no detail there. That's pages 5 to 6 of the supplementary bundle. And the counter schedule, the central point is at pages 12 to 13.
I don't know, let's just have a look at that.
Under Roman 3.
Sorry, I first of all I just wanted the counter schedule, the original schedule.
Oh, the original schedule, yes, is
S5 to 6. Where's the bit where it's got?
It's paragraph Roman 4. There's a long series.
Yeah, but where's the actual figure?
Well, the figures come in 6, Roman 6, but it's Roman 4 says reliance is placed on the accountancy evidence duly hardless.
Okay.
And then
So
we get
counter schedule.
And then my response, page 12, Roman 3, the defendant notes that sums claimed under these heads are based upon the income which is contended the deceased would have enjoyed from MRER Ltd out of salary and dividends, treating the claimant's own dividends and director's salary as part of the deceased's income. But no distinction is made between such part as may have been lost as a result of his premature death and such as not been lost, because it derived from the business as a going concern, continues to be generated, and so on. I refer to Wood and Bentle and Simplex and Cape and O'Loughlin. And then in the middle paragraph, middle of the page, insofar as the claimant was dependent upon income derived from MRER Ltd, her claim can only be based upon the extent to which such income has reduced, if at all. There remains, therefore, no properly formulated claim for the defendant to respond to under this head. I think that's probably all I need to refer to in the counter schedule. And turning to Ms. Hardless's report, taking it as quickly as possible, what she says, it starts on page 41. What she says at page 45, what she's instructed to do. 1.4, I'm instructed to consider the likely annual profit, both in terms of his salary and director's dividend, which Mr Rix would have enjoyed whilst working full-time. Likely annual remuneration thereafter, Mr Rix is expected pension income. 1.5, I've been instructed not to include multipliers. I have not been instructed to calculate the loss of dependency adopted in national trial date of 30th of June 2019. So it wasn't a dependency calculation, and she sets out, page 47, some further detail about the history. Can I just ask you to note paragraph 2.6, the sort of customers that they had achieved, Luton Borough Constable College, Formula One, Spec Sailors, Coffee Republic, South Bedfordshire County Council, and so on, and that they moved into purpose-built premises in 2015. And then turning to, that's referred to at page 54, paragraph, also on page 54, paragraph 3.24, their son Jonathan had been made a director and indeed was given shares, and we see that from the next page, before Mr Rix's diagnosis. And so the shareholding then became 40, 40, 10 and 10 for the two sons from September 2014. And then at page 56, introduced by paragraph 3.27, she sets out in summary form the profit and loss accounts for 5 years, 2.5 of which would have been before Mr Rix was unable to continue. So it's the middle of the 2016 year ended 30th of June year, December, that he ceased to attend the business. And we have the turnover figures. I have actually prepared a version of this which has the 2019 results, if your lordships would wish to have them.
Which is entirely up to you. I mean,
they are set out.
it seems to me that, but we're on a point of principle here, aren't we? We don't need to get into the weeds. We do need to understand, obviously, how basis 1 works, but save to illustrate this, we don't need to detail.
Well, my lord, yes, but I'm sure there'll be a response to the effect it was a question of fact for the judge based on the evidence before him, and so I do need to just make some brief points about the nature of the business.
Yes.
I've referred to the customer base, and we see turnover figures, and in 2019 it increased yet again to 1.9 billion, and we see under cost of sales there are wages and there are subcontractors, and they illustrate obviously that the business, the work is being delivered by other individuals. For example, in 2015, the wages and subcontractors came to nearly £700,000. And then we have further down we have the other income, net rent received. Your lordship see that just below the bottom hole punch. Rent received and deposit interest. And there's a note 1, right at the foot of the page, MRER owned investment properties which it rented out. And we see that there's an income coming in from there. It's a small point, but it's an illustration of the fact that MRER did have some investment income. And we say it's just an aspect of the overall business that it had viability to some extent, without Mr. Rix's continued presence. And then we see the level of retained profits. Profit before tax we see in the next line, and then we have less corporation tax, and then transfer. And the retained profit in the year, quite substantial sums were retained, except for 2016 when there was it went in the other direction. One ignores a revaluation of capital gain, revaluation of investment property, and there you have the profits before tax at the foot of the page, before director's remuneration, amortisation and revaluation. Amortisation refers to £28,000 a year for repayment of the capital of a loan. So having arrived at those figures, it's hardless at page 61, first of all, factors in some pension income, because Mr Rix had taken some small private pensions before he fell ill, and that is income that would have to be factored in. And then paragraph 4.10 on 62, this report is therefore prepared on the basis that the profits earned from the business, which would have been allocated to Mr Rix, were wholly earned by Mr Rix, would have been paid to him by way of a small director's remuneration and the rest as dividends. So that was the methodology. And it attributed to Mr Rix the dividends on Mrs Rix's shareholding as well. That raises my ground too. And then we have a section 5, expected performance of the business but for the onset of Mr Rix's illness. So this does appear to be a before and after comparison. And it's in foot of that page, 5.6. Therefore appears that in the year ended 30th of June 16, the business lost turnover and profit as a result of Mr Rix's illness and so on. And further, dropping down, middle of that paragraph, I have therefore assumed that but for the onset of Mr Rix's illness, the business would have achieved the turnover it actually achieved in 2017-2016. Turnover in the year ended June 16 would therefore have been 1.6 million, an increase of 13.2%. I've assumed, and then she makes further assumptions and further 4%. So it looks as though what she is doing is saying, well, we give the turnover an uplift by 13.2% and then add 4% growth thereafter. And that, of course, could have been used, but wasn't, as one approach to the way in which the absence of Mr Rix might have impacted on the family income. It's implicit in it is the proposition, which the judge also seems to accept, that the business does have a viability, as is obvious, even in the absence of its founder manager. And therefore, what the claimant was presenting to the court was, for the above-the-line calculation, the profits of the business, not simply the profits that had been achieved in the 4 years since, but a slightly enhanced profitability. But not just that increment of the enhancement, but the whole quantum. And then, just to quickly explain that with those figures, Ms. Hardless, in paragraph 7.3 of page 69, projects expected net profit of the business before tax, directors' remuneration and amortization.
Sorry, which page are you on?
69, 7.3, and she gets to 389,840 as the, this is the net profit. So before corporation tax and before payment of director's remuneration. And then she feeds that through in paragraph 7.11. She explains why she's 7.10. She's explaining why she's taking 70% rather than 80%, because that historically seemed to be what happened. And then, so she then works out a 70% dividend of £164,335 in 7.11. Then in 7.14 sets out the pre-income tax earnings, if that had all been distributed. So for 2019, for example, 176,792.
Where do we find that?
That's at on page 72. So it's the final. It's the table.
Got it. Yeah.
So that's the pre-tax.
So, you're on the table at 7.15.
No, it's, no.
The one on the top.
Because this is gross.
Sorry, the right-hand column.
Yes, 176,792.
Yeah.
And 715 is then after income tax in the hands of Mr. and Mrs. Rix. So what's assumed is that they would have, tax efficiency would have split it between them for their tax and that leads to, for example, page para 7.20, sorry, 719, page 74. She also adds in directors' remuneration and small pensions, and then we don't have to look at it, but she tells us at 720, Mr Rix's future annual net earnings after income tax, 108,678.
And that's the figure which appears in paragraph
Exactly.
100.
So that's how we got there. And so what she is presenting is everything that could have been obtained, building in a slight increase, 13% increase in turnover. In fact, the results later on turned out to be even better than she had predicted, because this report was written in 2018 and the 2019 results were better. But I'm not entitled to pray that in aid, merely to point out that she's doing her best on an estimate of what might have been the increment, as it were. But the overall calculation is simply everything above the line, everything that would have come to the family. And it's interesting to compare those figures, which include a total of 157,000 odd before tax, with historic tax returns, which are at page 88, read sideways on.
Why is that interesting?
Well, because one sees how much more. Because when I come to asking the rhetorical question, well, how should it be done? One way, of course, would be to look at the family income historically, and we see from
Which page are you on now?
page 88, my lord.
88.
88. Yes, it's an appendix to Miss Hardless's.
Appendix 8.
88, my lord. Yes.
But
The page is 88.
Appendix 8.
Oh, I'm sorry. No, it's page 88. It's appendix 7. And
My mistake.
we have a total.
You're looking at it, we haven't got it in landscape in the way that you're looking at it. We're looking at it in small print.
Yes, I've taken it out, but yes.
We're looking at that. That's right.
Oh,
I was
yeah.
confused by your...
Oh, I see. Oh, well, that's curious. I hope it's not too small to read.
Long time ago, a judge got very cross when I did that to him.
My lords,
Accused me of deliberately reducing the print.
certainly weren't doing that. But it shows the years, the fiscal years ended 5th of April 2012 to 2017 for Mr and Mrs Rix separately. And total dropping, it includes gross earnings, it includes benefit in kind, company car, partnership income initially, and then it became dividends because some of the parts of the business remained partnerships in the early years. And then you have the net dividend, tax credit, UK interest, some pension income for Mr Rix, and his total income for his tax return before tax is along the line towards the bottom of the page. As your lordship, can you read 61,621, for example, for 2012, running along, and ignoring 2017, which obviously is after he died. As a matter of pure arithmetic, the average earnings over those 5 years, 2012, 2016, is £49,487 gross. Mrs Rix, the similar figure for her, because she has some rental income from a property, they're higher, and her average for those 5 years is £63,730. And I merely invite the court to note that that's, over 5 years, a record of family income before tax, which we would suggest itself illustrates the difficulty about simply taking the profits of the company, including retained profits. And of course, profits retained and ploughed back in add to the value of the investment, because no one would suggest they've been wasted, just disappeared by being ploughed back in. So, Lord, Lady need from Sardless's report. The witness evidence, I think, is sufficiently set out in the judgment of Mr. Justice Cavanagh, but might I just make one or two points? I've already said that the sons were made shareholders and the older son director before Mr. Rix's diagnosis. And we have some references in Jonathan Rix's second witness statement, which in my submission are important. And that is at page 36 of the supplementary bundle. This is his second witness statement, and under the heading "My Dad's Role in the Business," in paragraph 8.
So which page are we on?
Page 36. He says, until 1994, the business was run from our home. It was in that year that my dad decided to purchase vegetable laminates. His plan was always to build the business to ensure that as a family we had financial security. Paragraph 9. I know that my dad was of the view that it was better to keep investing in the business rather than, for example, investing in a significant pension, as he would always have the ability to draw an income. And of course, implicit in that is that he regarded the business as providing a retirement income. Paragraph 11. My dad enhanced the laminate business by venturing into commercial bespoke work, example, airport security counters, school computer desks, shop counters and other products for large organisations. First purchasing Dunstable joinery in 2004, everything in-house and complement the building side. It would enable him to expand the business generally to enhance the service we offered and service a wider customer base. In paragraph 13, he refers to the combination of the business, which became MRER Ltd, and the need for a new purpose-built building. And then at the foot of that, by way of an example, we often do work for hotels. Previously, we've not been able to provide the materials for a 100-bedroom hotel. By purchasing and creating the new purpose-built building, we are now able to offer that service. And 14, it was in July 2015 that Dunstable Laminates relocated the new purpose-built building. It was officially opened by H.M. Lord Lieutenant of Bedfordshire. And then 17, we had finally got to the stage where all three companies were operating on a large scale with the capacity to take on large jobs and a larger turnover. It is devastating that that was my dad's ultimate dream, the reality that he had spoken about for a number of years. Sadly, he never really got the opportunity to see the benefits of his hard work. There were always therefore was always an intention to increase the turnover of the business. Paragraph 20, I have no doubt that if my dad was here, the business would have been more successful than it has been. And he refers to an impact on his health and stress. And I should just refer to paragraph 23 because I referred to it earlier. My mum and I find it very difficult to comprehend the suggestion that there has been no loss. But what we gain from that is that it was clearly always an intention, understandably in view of what we know about the business, to build it up to be a viable business to hand over to the family and to provide.
But what it also underpins is that description made by Lady Justice Smith in Williams that Mr Rix was the wealth creator, because what it sets out step by step are the various steps he took over the years to expand the business, to purchase businesses, and purchase in 2015 that very large premise, which sadly he never saw really to work in. And there is, some might say, the classic example of the wealth creator.
Well, my lady, we don't dissent from any of that, and I've already said I don't want to devalue Mr Rix's, and I don't intend to devalue Mr Rix's achievements, but the point is that this is what he has achieved. And so if, for example, he had decided, as he would be entitled to retire and hand over to his sons, and hadn't fallen ill, then what he would have achieved is a business that continued to provide an income. That's our point, and it's as simple as that. And so when Lady Justice Smith refers to Mr Williams as a wealth creator, we'll have to look at that. She was trying to get at a handle or a way of fixing or assessing the added value, and of course there will be added value, we accept that, of the continued presence of the deceased. But
hang on, sorry, you say there will be added value, you accept that, but
It's not.
You're
it's
not
added.
you're not accepting that. You're saying there's no loss. If
No.
there-
We said that the claim hasn't been properly formulated. That was our countership, because it's the whole of the profits. The added value approach is what was adopted in Williams and cases and Kane.
So is this your position? I'm sorry if I've taken a long time to get there, but I was very puzzled reading your skeleton argument. You're not really saying there's no loss. What you're saying is that in principle there is a loss, could be calculated on the basis of an attempt to assess the added value. There were some materials on which it could have been done in Ms. Hardness's report. Or it could be done on basis 2, which is a sort of market value of someone to provide the same services.
Yes.
But really, you're saying neither has been advanced.
That was our case below, and my lord, we're not conceding there is a loss because of this netting off. That's the problem. But
Okay,
as
I
it
mean,
were
I
above
just write this down. I accept not. Sorry, my statement of problems. Not saying no loss in principle. Brackets. There may be none in practice
after netting down.
after netting down. We'll come back to that later.
And that's a combination of the saving and living expenses that has to come into the calculation and the taking off of income in the hands of the dependent. So that.
Wait.
Sorry.
Subject to that point, that netting off point, loss could be formulated either by attempting to calculate, estimate is a better word, the additional income specifically attributable to Mr. Rix's services, for which some material does exist in the H report, or by the market value approach. But
Can I add, Lord, or by historic income, historic household income as demonstrated by tax return?
okay,
Say that again, please.
The historic income as demonstrated by tax returns.
but none of those approaches was advanced by claimant below, and judge's approach does not represent any of them.
Yes, I did advance basis 2, so there's that.
Sorry?
Basis 2 was advanced at the hearing. Basis 2, the cost of the replacement. Are your lordships referring to the?
Well, I thought you were saying it wasn't approach, and it wasn't. It maybe
No.
there were no material was provided in support of it. Maybe.
Yes. May I make, before coming to the authorities, we accept it's a rough and ready question. It's a jury question. Its precision is never.
What? No, sorry. I'm not asking about the merits of basis 2. I'm just trying to get at what your overall
Yes.
position is. I'm sure it should have been apparent to me from the start, but it hasn't been. And I now think I'm getting there, and that's why I'm taking the
Yes.
trouble to write it down in
Our
such
position is-
detail. But does it then follow from that unless you were going to take a very technical and absolutist position, which you've already disavowed, you are not asking for what you have asked for in the appellant's notice, which is simply that the whole of the award of a dependency be disallowed, but that it should go back to the judge to recalculate on one of these bases, which is, or some other if anyone thinks of one, all of which are more modest in approach than the wrong basis which the judge in fact took.
Yes, I don't think my own friend would concede they're more modest, but
Well,
is
that's
our
a risk you take. They may.
That would be our position, my lord. So
You presumably think they're likely to be more modest. Otherwise, you I don't forget that. Okay.
well, there are grounds 2 and 3 which are also relevant to both bases.
Okay.
Probably a good moment to take the court to the authorities, and I want to save time.
Well, Mr. Kent, before you do that, because like my Lord Vice President, I have grappled to understand exactly what your position is, both in your skeleton and in your oral submissions today.
Oh, I'm sorry to hear that.
No, not at all. But are we finally at this position that you are accepting in principle there has been loss? The fundamental concern is how that loss is calculated. Is that where we're at?
I'm accepting that, as it were, above the line, there will be
I
a
don't
gross...
find above the line a useful phrase. I don't know what it means.
Well, no, we're not accepting that there will be a loss, because
I said in principle there will be a loss.
Yes, in principle, I think my lady means as I is a shorthand for acknowledging you may have points about the netting down for saving of living expenses.
There could be a loss. There could be a loss.
Yes, I think a better way of putting it is to say we undoubtedly accept that Mr Rix's continued involvement in the company had value.
Yeah, but that's not... I certainly understood from your skeleton argument that you were saying the answer to this case is just look at the figures, the business is making more money afterwards than before. Therefore, end of story. Now, maybe you were never intending to run that,
Well,
but that's what it looked like.
I was responding to the way in which the case was put, which was that you look at... it wasn't... They didn't rely upon Miss Hardler saying, well, the turnover would have been 13% higher. Or put any other, until we got to basis 2, which was adopted shortly before the trial in the skeleton argument. Although I think had been flagged up to some extent, I think it's fair to say in my own friend's schedule of loss. Our appeal, of course, is against the judge's findings under basis 1, which is simply look at the profits that would have been enjoyed. That's your starting point.
Well, what are you asking? What do you want the outcome of this appeal to be? I'm sorry to ask you rather bluntly.
If I'm reminded that we said there should be no loss. Since the notice of appeal, Lord Justice Bean has given some guidance in the case of Head and Culver in a slightly different context, and we therefore, I think, are constrained to say that it would be wrong simply to say the claim fails if our ground 1 is right. That there are other ways of doing it, and even without a respondent's notice, we accept that the matter can go back for further investigation on what we would say will be a proper basis, guided by your lordship.
So it should go back. You're asking the court to allow the appeal to remit it.
I think that's what I think.
That's in essence what
I think it must be.
You know, 5 to 12. We finally, my part, I've only just got to where I'm sure it's my fault. Where you want us to go, but that's the point.
Yeah.
Anyway, you're going to the authorities now.
Well, Lord, yes.
It sounds like the head authority is going to be quite important in your.
It may be. Yes, I'll have to come to that.
Because that's why you've shifted. You've slightly adjusted your position, I think.
Yes, because we had a similar issue in head, and it was dealt with. I'll come to it. The first, to try and avoid unnecessary reference to authorities, my first point is that the authorities show that it's the defendant who must establish a loss for herself, not a gross loss.
So what are you about to give us some propositions?
Yes, but I'm simply going to refer to the skeletons to save time.
Oh, I see, yes, fine.
Because I think I've set out the...
By all means.
Sufficiently
Just show us
set
the
out.
passage you're, as it were.
In paragraph...
You want us to underline.
paragraph 5, Nauer and Ministry of Justice, Lord Neuberger and Lady Hale giving a joint judgment in a fatal accidents act case, aiming at awarding damage in the law of tort to place the person who has been harmed by the wrongful act in a position which he would have been had the harm not been done, full compensation, no more, but certainly no less. And then in the next paragraph, there's also a reference. There's a reference to part of their judgment where they refer to respects in which the current legislation requires that claimants be overcompensated. And they give an example, which is section 3.3 of the Fatal Accidents Act requires the court to ignore not only the prospect but the actual remarriage of the claimant. Another is section 4, requires benefits which will or may accrue to the person should be disregarded. These are, of course, examples of overcompensation. They result from legislative choices and not, unlike the principles with which we are concerned in this case, from judicial decisions. So there's no question of some sort of artificial methodology being adopted. It's the loss, subject only to those exceptions where there might be overcompensation.
And those only statutory exceptions are permitted. Is that your case?
Yes, and that's what Lord Neuberger and Lady Hale that it's full compensation, no more, but certainly no less. And the judge noted, as I've already said, that the principal battleground is section 3, not section 4. Set it out. Then paragraph 9, Davies and Powell Dufferin, Lord Porter, saying it's in each individual claimant, each individual dependent, you must be considered separately. Refers to a 19th century decision. And in Lord Wright, in the same case, in the next paragraph, it's a hard matter of pounds, shillings, and pence. So those are the key authorities. It's what has been lost and will be lost on the balance of probabilities. We accept that can include loss of capital or income derived from capital as much as loss of income from salary, as long as it's lost. The case of Pym was an example where settled estates, of which the deceased was the life tenant, went to the next life tenant, and his 8 younger children and his widow therefore lost out. An example of capital which moved in a particular direction. So those individual dependents, said the Court of Exchequer, I think, had a claim, even though the estate was intact and now in the hands of the oldest son, who obviously was keeping it for himself. So it is a question of loss. Then the trilogy of cases, Wood, Cavanagh, O'Loughlin and Williams. Wood is at tab 8, and I've had put on the bench, I think a breach of protocol, a report in the personal injury and quantum reports, because the one in the authorities bundle was simply the judgment.
Yes. Thank you for doing that. I'm not sure it's any more legible actually than the one we've got, but I agree it is a report.
I think it's a bit more legible. It's not, I'm afraid it means we have to look at the rather pale numbering bottom right.
Yeah, can I just say for the future, I think I speak for all of us, but anyway, I speak for myself, that when you're doing law reports, it's much easier to have the PDF actually looks on the page. This is a printout from the screen. And if that message could go back to your chambers or whoever produces these bundles.
I will bear that in mind.
Because you actually get these very long lines in quite small print, so less easy to read than the ordinary version. Okay, where are we?
This is Wood and Benthel Simplex. And this is the starting point of, and it's Lord Justice Staunton in particular who discusses the hybrid situation. I just want to make the point about this. It's a slightly complicated story. A young farmer died, and he left a widow and family.
So sorry, it matters less. But why is this different from the one we've got in the?
It's well, unless I've got the one I had in my bundle was simply the judgment.
No, you're right. You're right. It is better.
We have a head note.
It's got a head note. Yeah,
that's the only difference.
Yeah, no, that's fine. Thank you.
I'm trying to avoid.
No. Let's not spend any more time on this. I just wanted to understand.
And so the point about that was that it was complicated to get at the dependency because it was a farming enterprise where the deceased young farmer, who was I think 30, quite young anyway, didn't pay himself very much, and his brother but it was quite a valuable property. And the first point to note is if one turns to page 8 of the PIQR report, in the second full page, we have this well-known accountants. Does it have that? Well-known accountants had been instructed on both sides to examine the farm accounts and had prepared reports on the value of the dependency. In due course, they agreed that the appropriate figure for dependency after the deceased death was 14,211 per annum. So it needs to be borne in mind that there was agreement about the, as it were, the gross dependency, the gross loss of that relatively modest amount. But the argument put forward by Mr. Livesey, Queen's Counsel on behalf of the defendant, is seen in the middle of that page. Because due to complicated transactions that took place after his death, the widow received some 20% of the farming interest, and also some grassland was given to trustees for the children's benefit. And this resulted in a total of £7,500 per annum being paid to them. And therefore the argument was that the 14,000 should be reduced pound for pound, and the award should be an annual figure of £6,711. The Court of Appeal rejected that argument, as did the trial judge. And they rejected it principally on the basis of Section 4 of the Fatal Accidents Act. But in the course of doing so, there was discussion about what you do about these business cases. And Lord Justice Beldam, in page 9, just slightly above halfway down, no aspect of the law of damages has been found in practice to be more dependent upon the facts of each particular case than the assessment of loss of pecuniary benefits, the dependence on the Fatal Accidents Act. Helpful to begin with certain underlying principles without regard to the current statutory provisions. The foundation of the claim is dependent.
If there are any long passages, it's quicker for us to read them. How much do you intend to use?
Dropping to it's to the point.
Just read A to D. Okay, we'll do that. Give us 1 second. Yeah.
So as long ago as 1953, we have the point that if the assets were continuing to benefit the dependent after the death, then they weren't taken into account. And then if we go to page 11, right at the bottom, last paragraph, Mr. Livesey relied upon Auty and National Coal Board, which I think your Lordship may have been involved in.
I was in that, yes.
Which was about pensions, and again concerned an argument, a widow's pension, and the argument part, there are a number of different cases, whether the surviving pension was a benefit that had to be taken into account. In the Court of Appeal, Lord Justice Oliver, foot of the page, his solution to the problem, and then it's quoted. Your Lordship want to just read the quote from Lord Justice Oliver.
Yes, just give us a second.
Foot of the page.
Yes, I mean, it was a very straightforward case, wasn't it? I mean, he'd lost his pension, but he got, I think, not the full amount, 2/3 of it as the widow's pension,
Yes.
and yet she was claiming the whole of the loss of his pension.
Exactly.
We as for the defendants, were saying it's all just the pension.
Yes.
You can't say she's lost it, she's just got it.
Exactly.
Yeah.
It had a net present value, as it were. And so, but it provides the starting point for this discussion. And then Lord Justice Beldam goes on below that, no doubt where a dependent claims for loss of expectation of pecuniary benefit, which is the very thing which the dependent is enjoying as a result of the death, it can, as in the case of the eldest son in Pym and Great North Railway, be said there's been no loss and no injury. Thus, the question of disregarding the receipt of the pension did not arise. Well, the eldest son was the next life tenant, so he got the whole of the settled estate. The 8 younger children did have a claim. And then, but where there is clearly established a loss from one source, the fact it may be made good from another by using a benefit received from the estate of the deceased is beside the point. Lord Justice Oliver made this clear when he said after setting out the provisions. And then another quote from Lord Justice Oliver, 2 stages to the inquiry.
Yeah.
And Lord Justice Belden concludes, I would therefore hold on the facts of the case that the wording of Section 4 of the Federal Accidents Act required the benefits which accrue to the dependents be disregarded. So that was a Section 4 case, but it does have these dicta or comments about how you get to the loss in the first place.
Mr. Kent, you rightly describe it as a Section 4 case, but what is clear from the judgments is they look at the correlation between Section 3
Yes,
and
they do.
Section 4.
Yes, they do, indeed. And that's why it is valuable and why it is relied upon by the later authorities. And Lord Justice Staunton, he sets out the principles, page 13, 2 paragraphs from the bottom. He refers to Bishop and Cunard White Star. He starts off, what are the case where the asset inherited by the dependents was indeed the
It must be source.
source, I think it must be, of the income on which they had formerly dependent. Bishop and Cunard White Star. To take Justice Hodgson, the extreme case where the whole family income is derived from the husband's investments.
Yeah.
So on. And then he says, the question to my mind is whether that principle was changed in 1982 by the introduction of the new Section 4. It was then that a much wider Section 4 came in. It had previously just been insurance benefits, essentially, that were to be disregarded. To adopt a familiar and homely metaphor, can the dependents inherit the goose and still claim they have been deprived of the eggs? And he then says he doesn't think that's what Parliament intended in enacting the new Section 4. And second paragraph on page 14, however, there would be surprising results if the effect of the new section is that damages can be recovered for lost support, although the only source of that support is inherited by the dependents. A rich man with investments worth £1 million and no other income is killed, and so on. And then he says, in my judgment, such cases are not concerned with the question whether a benefit accruing to the widow should be deducted, but with the loss that she has suffered. In financial terms, she has suffered none. It refers to Lord Justice Oliver and Orty. And then, importantly, in the middle of the page, there can be no doubt that the law does, to some extent, allow greater damages to be awarded under the Federal Accidents Act, and a strict view of the dependent's loss would justify. Examples were given by Lord Justice Purchase. Nevertheless, I hold that before one considers deductions under Section 4, one first has to determine what loss the dependents have suffered. If they have inherited the source of the income upon which they were dependent, they have not lost it. One then turns to the case where the income is in part derived from labour and in part from capital. Suppose the husband owns a boarding house, he and his wife run it together. If he should happen to be killed by a negligent or wrongdoer, his widow inherits the house and continues to run it, should she recover to the extent of her dependency on the whole of the profit of the boarding house? That is not very different from the present case. My answer is that one must again determine what the dependents have lost. No question of deduction arises. The court has to ascertain how much loss has arisen because the deceased is no longer alive and able to work, and how much of the deceased income is derived solely from capital which the defendants have inherited. And he considers the facts of the case and concludes that it would be absurd to suggest that the loss was as little as the defendant was saying, and so the appeal was dismissed. Except those facts are different, but they provide the starting point for what was then considered by this court in Cavanagh J. This is an unreported decision that has been relied upon a number of times. And the point here was that Mr. O'Loughlin, who died at the age of 50, had fairly recently set up a property development business. He was essentially a property developer. And what the judge awarded and the Court of Appeal upheld was a loss of dependency based upon the net cost of employing someone to carry out his functions effectively, put at £23,000 per annum. And he did his, it was all in the Republic of Ireland, he ran his business through 2 companies. It was slightly more complicated because he also had a 50% share. We see this in paragraph 3 in 2 companies, together with a Mr. Howley, who owned 2 other properties. And we see what his gross income was in the middle of paragraph 3, $92,000, and so on. And so Justice Latham says these figures are to extent artificial and significant part constructed so as to take as much fiscal advantage as possible in the period leading up to his death. Because the essential benefit of his activities was property development and therefore capital gains on the properties as they were developed. And what we see in paragraph 4, Lord Justice Staunton in Wood and Dental Simplex is cited, and five, on that basis, contended the loss to the dependent as a result of Mr. O'Loughlin's death was his flair, experience and entrepreneurial skills to manage and develop the property portfolio, the financial benefits it would bring to the family. Dropping down as a result, it could have been anticipated he would have increased the portfolio and the rental income by acquisition and development, which are clear benefits which the dependents have now lost. Submitted the most secure way to assess the value of these services to determine what it would cost to replace them. And Mr. Washington gave evidence about that. So it is very clear that the approach adopted was to say that there has been a loss to the dependents from the loss of his flair, experience and entrepreneurial skills. And a way of, as it were, getting a handle on that was to see what it would cost to replace his services. There was no question in that case of saying, well, let's look at the gross profits of the businesses, and simply award that as the starting point. In over the page 175 of the bundle, middle of the page, the Lord Justice Leighton is quoting Sir Justice Forbes, I think it was, the trial judge. In the middle of the page, there was considerable development potential in some of the properties which he had acquired. All the skills which Mr. O'Loughlin brought to bear on his business and the time, effort and energy which he devoted to maintaining the building up that property portfolio were, in my view, clearly of economic or pecuniary benefit to independents, which have now been lost. And so that was the approach that was adopted, a conclusion that there was a loss, and then an attempt to put a value on it. And we see that in paragraph 15.
Well, can we just see what Mr. Elliott was submitting at the top of 9?
Yes.
In first half 9. He submitted that there was no reason why the dependency could and should not have been calculated on the traditional basis of determining the probable financial consequences had he lived and continued to manage the business, and comparing it with the probable consequences of his no longer being in a position to do so. I mean, you would have been happy with that, wouldn't you? In principle,
well,
it's another way. It's the argument here was effectively whether you should go by basis 2 or.
I suppose it was.
Yeah.
But the essential point is that no one was arguing that you just look at the gross profits of the businesses and take that as the starting point. And indeed, in paragraph 17, before coming to 17, paragraph 15, Lord Justice Leighton says the judge came to the clear conclusion that the defendants had lost the flair and business acumen, which would by clear inference have resulted in a successful development of the property portfolio, which represented the family's assets with consequences.
So where are you reading from?
15, the first few lines.
15, I'm so sorry. Yeah.
With consequential income.
How much of this do you want us to read?
To the end of that sentence, in fact.
All right, okay.
So that's the foundation of facts and finding. Consequential increases in both capital income and value of the portfolio. And then in paragraph 17, this makes my point. In the quote from, I'm not sure this is a quote, in fact, I think this is Lord Justice Leighton. It seems to be indented for some reason. The paragraph that begins, I confess to being somewhat puzzled by this argument. Mr. Elliott suggesting this case should have been about section 4.
Section 4, yeah.
Rather odd for the defendant.
Well, anyway, yes.
But Lord Justice Leighton says he's puzzled by it. The section is intended to provide a benefit to the claimant, not to the defendant in the Fatal Accidents Act case. In the present case, Mr. Burton QC, he's counsel for the claimant, did not seek to argue, either before the judge or before us, that any of the capital assets which devolved upon her as a result of the death of Mr. O'Loughlin amounted to benefits which should be disregarded pursuant to Section 4. He was content to accept the principle referred to by Lord Justice Belden in Wood and Bentham Simplex, namely that assets which the dependents were enjoying and which they had the benefit of during the deceased's lifetime, which they continue to enjoy after his death, are not to be taken into account either as part of the dependency or as a deduction from it. And so again, there was no basis one being put forward in Cape and O'Loughlin on behalf of the claimant. And then the next, we then come to Williams, the Welsh Ambulance, tab 15. Again, unreported, but regularly referred to. And we have here a slightly complicated story because Mr. Williams, who was quite young, he was 49 when he died, had established three things, essentially: a builder's merchant business, and he had an interest in property, and he was a property developer, and he also had a steam engine collection, which had value. But the builder's merchant business is probably nearer to our case. And we see in paragraph 8.
Are we looking at the report in this court or in
yes,
or Judge Hitching?
Yeah, Court of Appeal.
Yeah.
And paragraph 8, Lady Justice Smith. The family's financial position in the period before Mr. Williams' death was extremely comfortable. In the year ending 31st of March 01, the business profits were about 324,000. Capital accounts 1.6 million and 650,000 pounds in cash. In addition, Mr. Williams had amassed a family property portfolio. And so that was, and then paragraph 9, the income position was also very satisfactory. At the year ending March 2001, each partner was entitled to 88,630. Now, 10, as the judge observed, the business had grown as a result of Mr. Williams' drive, energy and flair. The property portfolio and the steam engine collection had all been financed from the business and had grown in value as a result of his keen eye. Good investment. The judge aptly described Mr. Williams as a wealth creator. Then in paragraph 13, we have the situation after the death, anxious and distressing time, but their efforts have been rewarded by the continued success of the business. In the years since Mr. Williams' death, the business turnover and profits have risen. Each year, profits have exceeded £400,000, and so on. So rather like this case, you have, as a matter of fact, increasing profits. But we then see in paragraph 15 what the claim was on behalf of the claimant, which was as far as the builder's merchant business is concerned, the cost of his replacement as the manager of the builder's merchant business. This is the middle of paragraph 15, which was agreed, in fact, I think at the trial, as £87,500 per annum. And so the first point to note is that is the way in which that's the starting point for the dependency calculation, not the £500,000 odd gross profit, or £400,000, from which one then derives a lost dependency, but the cost of replacement. And Lady Justice Smith accepts that approach and explains why that is a proper approach. Paragraph 31 is a point in passing because all the family were claiming as dependents, children and widow, and for reasons best known to the parties there, it was agreed at first instance that the judge would make a global award, wouldn't seek to apportion between dependents. And Lady Justice Smith is addressing that. And at the end of paragraph 31, she says, but it is sufficient if the claimant shows that each alleged dependent had an expectation of future benefit, whether in money or services deriving from the deceased, which has been lost as a result of the death. So nothing exceptional there. And in paragraph 37, she says this, paragraphs 54 to 55, the judge can turn to consider what the position would be in a case in which the...
Do you want us to read the whole paragraph?
Well, yes, it would be helpful.
Yeah, well, this is simply reciting what His Honour Judge Hickinbottom, as he then was, which I won't say again, had decided. I mean, I did find his judgment also very helpful.
Yes, well,
Yeah.
there it is. I think it is. And what we... so again, we say that's entirely, as we submit the authorities demonstrate. The need to separate out capital which did not give rise to any loss of dependency and income which had been earned and which would give rise to a loss of dependency, because it would come to an end at the death. And there's then reference to Cape distribution, Lachlan, and noted that the judge said that that case bore considerable similarities to the present case, although Mr Stevenson for the defendant submitted it to be distinguished. And then there's quite a long quote from the judgment below, and it's worth looking at the citation on page 254 from paragraph 65 of the judgment. The fatal flaw in these linked submissions...
Again, do you want us to read the whole
Yes.
of paragraph 65? Yes, this is helpful because in the parentheses he makes it clear that when you leave out the capital, you also leave out the income derived from that
Yes.
capital.
Yes, sometimes it's confusing because there's reference to inheriting the capital, because what matters is what that capital will yield in terms of income. And so that, and going on to paragraph 67 of the judge's judgment quoted, lost of very, very considerable skills and services, wealth creating property and steam engine, builder's merchant business, wealth creating property and steam engine. These can be valued in money's worth, and in the circumstances of this case, I consider their dependency can most appropriately be measured by asking how much it would cost to replace those skills with another person. And so that's the judge's approach, which was endorsed by this court. And I think what I need to take the court to is paragraph 51, an important concluding paragraph, Lady Justice Smith. I invite you to read in full.
Yeah.
And there's a reference there in the third line to the judge being asked to do it on a global basis. One of the points of distinction, of course, is that in that case, the assets were owned by Mr. Williams. It was a partnership, although it didn't appear that the partners owned any of the assets, because there's reference to them inheriting them later. Things are slightly more complicated in a case like this with a limited company, because of course MRER Ltd is not a dependent claiming for the loss of Mr. Rix's services. It's the dependent's loss, and how, therefore, one has to feed it through the accounts to see what the dependent...
Yes, but all the authorities say you just take a realistic view toward that.
Well, that's my ground too, which I'll but I'm not saying, and indeed there's authority against me, that because you interpose a limited company and there's no loss to the
Right.
dependent. I'm simply saying that it's not so straightforward. Where you have a family who and all the assets were owned by Mr. Williams, and he is there no longer there to administer and run them. That it's rather more straightforward, particularly where it's done on a global basis, than where there are of course other shareholders. Then. Paragraph, the proposition that it's fixed at death, again, I think I can take that fairly shortly. And what this means, in my skeleton argument, I dealt with that at paragraph 19. Lady Justice Smith, the only post-death events which are relevant to those which affect the continuance of the dependency.
Yes.
And what I say is that that mustn't be read out of context. And I then cite McGregor on damages, and I put in the 21st edition is now out, but it says the same thing at, I think, the same paragraph, 41A32. And Williamson and Thornycroft, which make it clear that one doesn't ignore what has happened. It's what you do. It's what you do with the evidence as to what has happened since the death. And indeed, I've added to the authorities bundle a case called Kerwin and James back in 19.
Well, that's a famous case, yeah.
And that,
Well, that's a classic case
yeah.
where someone who suffered an injury, perhaps I'm confusing, there's several cases, but I think isn't this the one where they've suffered an injury? Oh, no, that's right. It's where
She remarried.
she'd been married and
Before the appeal is
it was
heard.
before at the time of the trial. It was taken into account that she had a prospect of marriage, and the whole issue was about that. But by the time of the appeal, she had been married.
That's right, and it was a question of whether fresh evidence would be allowed, and Lord Justice Harman said that.
But a more classic example is where someone dies between the accrual cause of action and from another cause, to make it as difficult as possible, unexpectedly. So the life expectancy, if you'd assessed it at the date of death, would have been 10 years or 20 years. Date of the injury was 10 or 20 years. But by the trial, you see unexpected, they died after 2 years.
And we say there's nothing special about fatal accident claims. This is true in the law of tort generally. It's the expectation as at that event.
But speaking for myself, I see all that, but I don't quite see why it's relevant to the issues in this case. Did the judge really take it into account in this sense?
Well, it's one of his points that he makes in that paragraph 60.
Yes, but
it's one of the steps towards.
Well, more important to see how he deploys it in his actual reasoning.
Well, it's paragraph 94, I think. Paragraph 94, second sentence. The income of the dependent from the business after the deceased's death is irrelevant.
But it's not for that reason. It's because what you're... Oh, I see. Well, okay, I won't have a debate with you. I'll read it again in the light of...
It is in the context of basis 1. And so what we're saying is evidence of what happens after the event, by the time the case comes to trial, is always admitted, but one has to be careful what you do with it. It's evidence of what the expectation was and which has been lost.
But the proposition that he was addressing in this part of the argument was not the proposition that you're advancing now. As I read it, but the confusing circumstances, trying to work out what the real issue is, he was addressing a suggestion there had been no loss, full stop, as a matter of principle, simply because they'd made the business was more profitable in the years after his death than before. That seems to be what he understood your submission to be. It's not the submission you're advancing now, but it was what, and that's what he was addressing in the whole of this section. Look at issue 1 is, which is the heading is at page 56. Is Mrs. Rix entitled to a financial dependency at all? And I think he understood your submission to be, rightly or wrongly, that it was enough to point to the accounts and say, well, their business is making more money after than before. Well, was that not your submission?
Yes, but it was based upon what we said in the counter schedule, which was that the case being advanced was, as it were, the gross loss, the gross profits, based on the gross profits that would have been enjoyed, without regard to whether they were lost. And then he said the claim, therefore, is not properly formulated.
Well, I don't know. If you look at how the submission that he understood is the one at para 31. Mr. Kent submitted in these circumstances, i.e. the company was making more money, it would make no sense to conclude she suffered any financial injury as a result of her husband's death for the purpose of Section 3. This isn't a fancy point taken on the way the case was pleaded. It is an important point of principle. And that's what he's addressing in all these paras. And in that context, what he said about some, you don't look at what happened after the death, is unexceptionable and right.
Well,
the real issue, it seems to us, in the light of the way you've clarified your case this morning, is what he says about issue 2. How should the financial dependency claim be quantified?
yes.
Recognising that on one basis of quantification, it may still come out at nil because of all the things that had to be netted off.
Yes.
But that wasn't the point he was addressing at paras 30 to 87, was it?
Well, the point that he was recording in paragraph 31 was that on the basis put forward, which was simply that it's everything that was produced by the business. Look at before and after. There's no basis even for identifying a loss on if that's the way in which it was to be put.
Perhaps I've been not totally fair to you, because actually the objectionable paragraph does come under heading 2.
Yeah.
Heading,
Well, I'm saved by that. But Lord, I can also
but
say...
I still, the broader point is I think right, that a lot of this judgment is concerned with a point which is not now what I understand you to be saying.
Well, Lord, insofar as basis 1 is supported, I continue to say it. The paragraph 107 shows the judge's workings based upon Ms. Hardless's report, as we've seen, can only be can only be explained on the assumption that when the judge said what happened after the death is irrelevant in paragraph 94, the income of the dependent from the business after the deceased death is irrelevant. He means that you ignore it. Not simply, he's not simply saying, well, the fact that the business has done very well doesn't prove that there isn't a loss. What he's saying is it's irrelevant, and he must mean in paragraph 94, because this is what he does in paragraph 107, you don't deduct it. Anything that survives to the claimant. All that is deducted is the $23,000 odd a year from her income from a rental property. So, whether I've misunderstood what the learned judge meant, there's no doubt that his judgment is founded upon the proposition that the income from the business is still to be enjoyed by Mrs. Rix, or by those who inherit the asset, the shares.
Actually, how he deploys it is in what he says in 94 is then relied on in 97 in answer to a submission of yours at 96, which was that if he didn't accept your primary submission, you would quantify the loss by comparing the profitability of the company in the period after he died with an estimate of the profitability if he had survived.
Yes.
And that's really you're advancing that again before us as one possibility, and you're saying that there's some material for it in yes.
And I don't say that the judge will be bound by that paragraph, Ms. Hardless. I accept that some broad brush approach might have been adopted, such as 10% greater turnover. The point here being made is that was what was happening in Cape and O'Loughlin by finding the loss from the property development business could be measured by reference to the cost of replacing his services by a skilled surveyor who would know how to develop property. And so it's a proxy for the loss. But going back to 94, we can see at the end of that, there's a reference to Lady Justice Smith in Arnott and White, and which he quotes. The Act now I think requires only the quantification of loss of dependency. Once the loss of dependency has been calculated, there's nothing to be deducted. That is what Parliament has decided. The fact that the claimant will in many cases receive more than she has lost is nothing to the point. But we can take court to it if necessary, but that was a reference to section 4, and therefore in a circumstance in which one might have an assessment which exceeds the loss actually suffered because of benefits received.
Mr. Kent, I know you say it's a reference to section 4, and I'm not disputing that at all, and I'm not necessarily asking you to go back to the authority, but what is clear from the authority and the judgment of Lady Justice Smith is she's looking at the interrelation between 3 and 4 again.
Yes.
It's not as clean as it is
No, I
section 4.
accept that. Yes. But the reason I referred to that is that that is support for my proposition that because he ends that paragraph with that observation that Lord Justice, Mr. Justice Cavanagh, when he says the income of the dependent after the deceased death is irrelevant, he means is to be ignored. Not irrelevant in the sense of having no evidential value to the loss, but it is actually to be ignored, and that's why he is able to ignore it in paragraph 107.
Well, 94 is a summary of the principles he set out in 1890 to 93, isn't it?
Yes, that's right.
You don't quarrel with the principles.
Well, the problem is one can take passages and say that one doesn't quarrel with them, but we know what they lead up to. So we say there must be a misdirection, which requires the continuing income to be ignored if the claim is put on this gross basis, the basis 1. If as in Cape and O'Loughlin and in Williams, the claimant's advisors didn't seek to put it on that gross basis, didn't seek to rely upon the profits of the business, but sought to focus on the value, a way of assessing the value of the deceased and his flair and contribution, then there's no problem. But if it's going to be done on this above the line, as I put it, what profits would have been enjoyed, but then below the line you ignore the fact that they continue, then we say that is a misdirection.
You keep using this phrase above the line. I don't quite know what you mean by it. Just spell out again.
I'm
Above
sorry.
the line. Spell out again what you mean by above the line.
Well, this is the Coward and Comex calculation, which is that you add together the income from dependent.
Forget Coward and Comex. When you're using the phrase above the line, what are you meaning by it?
I'm meaning the loss which the fact of the loss of the income which the deceased would have been able to contribute to the household income before you net it off. Firstly, by taking off the saved living expenses proportion, and then by surviving income in the hands of the dependent. So, for example, if the judge had said the turnover would have been 10% higher than it has turned out to be, then you have a figure that the accountants could work through the accounts, arrive at an increased profit figure for the company, which would have been distributed, and then arrive at a...
Are you saying above the line is the wrong approach?
No, that's the correct approach, but I'm saying that when you decide what's to go above the line, if you're putting above the line all the profits of the business...
I thought you were describing the wrong approach as the above the line approach.
No, Lord, what I'm saying, and this is what I was saying in my submissions that I took the court to the judge in the transcript, that if you're going to do it that way, which is to look at the profits of the business as they are projected to have continued had Mr Rix lived, then you've got to... That goes above the line, but then you need below the line to take in the surviving profits, to compare like with like. That's all. Whereas if you do it in a completely different way, then what you put below the...
I may have misunderstood all this. I thought that your bull point was that you have got to do the exercise that Lord Justice Staunton said you've got to do, you've got to distinguish between the benefit that has been retained because the deceased has, not the deceased, sorry, the survivor has got all the assets. Just assume there was no, assume it's 100% shareholding, assume that the no family. It's wrong to give the income that's derived from the assets because she has inherited all the assets. Therefore, you've got to look at the distinction between what is merely the income you get from the assets you've inherited and the added value from the dependent still being alive to manage that. And that's your point, isn't it? I don't quite see what above the line and below the line has got to do with that.
It actually comes to the same thing, because if the household income would have been 10% larger than it has been, then you can have 110% less 100%, and you get at the net amount. Or you could just put 10%.
Well, that's an incredibly complicated way of looking at it to me, but conceptually, which is really what I'm interested in, once you've got the concepts right, you can work out how to give effect to them in practice.
Yes.
Is this right? Conceptually, your point is where the judge went wrong is that he did not, the approach which he adopted did not distinguish between that part of the income which reflected the fact simply that she had inherited the whole of the business, in all the son's contributions and so on, and that part which was attributable to her husband being alive to run it and add value to
continue adding value.
Exactly.
So, yes, that's correct.
And as you say, there are various different ways in which you can assess that, but whatever it is, it will be less than the mere amount that you've inherited, because whatever the value, in a case like this where there's a lot of capital and assets and goodwill and so forth, those will have some value which you have inherited. And when I say value, income generating value.
Yes. Yeah. So, Lord, we say, can I just quickly take you to the final parts of the judgment, which we say...
we haven't looked at head yet, which you said was obviously...
No, that's true. Can I just invite the court to note that I made submissions about the nature of the company in paragraph 64, describing it as mature and robust. And exactly the point that we've been debating.
This isn't part of the judgment, as the Lord says. It relates to the question of whether there is a dependency at all, not in the basis upon which it should be calculated.
Yes, but what I wanted to draw attention to is that having set that out, and my submission in paragraph 65, that the argument I put forward is not fall into the trap of taking account of events that post-date Mr. Rix's death. Rather, the argument is based on the state of the business before Mr. Rix died. He says, I do not accept this submission. He doesn't really say what parts he doesn't accept. And he doesn't.
Where are you? Sorry.
Paragraph 66. And so he then says, whilst there will no doubt be cases in which it's difficult to differentiate between capital or income generating assets which are unaffected by the deceased's death, continue to provide an income after death and the income from the work and skill of the deceased, this is not such a case. Wrong to regard Mr. and Mrs. Rix's shareholding in the family business at the time as being an income generating asset, independent of the work and labour of Mr. Rix himself. But although he says that, he doesn't say that he disagrees or makes a finding contrary to anything I submitted in paragraph 64. And in my submission, nor could he, because quite clearly the business had reached maturity and was capable.
Well, really what he's saying, appears to be saying in this passage, is every penny that the business made is to be attributable only to Mr. Rix's.
Yes.
And you say that's simply wrong and contrary to...
Contrary to the evidence before him.
Well, what he's rejecting in 66, I think, is what you're saying in 64, isn't he? I mean,
well,
he doesn't deal with every point you make, but your point was that there was no clear dichotomy between income generating or capital asset on the one hand and earned income in another, in the context of this company, mature company, my phrase.
Yes.
And you pointed out that her interest in the business was akin to, by that stage, an income generating business. And he doesn't accept that.
Well, he doesn't.
He says it. He says it about 5 lines down in 66.
It would be wrong to regard the shareholding as being an income-generating asset,
Yes.
independent of the work and labour of Mr Rix himself. So he rejects your submission. On
He's rejecting, the way I read it is he's rejecting your absolute submission. But your position, I think, has to be that he shouldn't have thrown the baby out with the bathwater.
Yes.
I couldn't say it could all be disregarded, but some of it still had to be disregarded, and the method he eventually adopted didn't do that.
Yes, exactly. My lord, it obviously was an income-generating asset, independent of him to some extent.
Yeah.
And that, he says, demonstrated by what's happened since. And that's part of the relevance of the later evidence, to get at what the expectation was. And the learned judge seems to approach it on the basis, as I've said, that there's no such thing as a hybrid, that it's all or nothing.
So it's 102 where he comes back to this point when we're looking at the calculation.
Yes.
So there he says it's only the income produced by his labour,
Yes.
not with income produced by capital assets or mixture.
Yes.
So that's his assessment of what we're dealing with here.
Yes.
It appears at various points.
Exactly. And he's assessing the labour as everything, the whole of the profits of the company.
But I don't quite know why he says that. Does he mean that because it's all generated by assets which themselves were generated over the last 20 years? But you would say that's not really the point.
No.
That will always be the case in these sorts of family business cases. That's really where, if your analysis is right, he goes wrong.
My lord, I ought therefore to come to Head and Culver, not least because Lord Justice Dean refers to Mr Justice Cavanagh Rix, so we were rather strange, self-supporting situation where...
Well, let's look at it. Yeah.
That was a rather similar in many ways. This is at tab 20, Judgment of the Court of Appeal, by Lord Justice Dean. And this was a business, again, set up over a number of years, air conditioning and so on, which had achieved some quite substantial income. And the time of the trial, Mr. Head was still alive and gave evidence, and it was a lost years claim, so one had to take a view as to what he would lose as a result of the no longer being there to run the business, and slightly different methodology to a dependency claim under the Fatal Accident Act, but there obviously are similarities. And Lord Justice Bean noted that the trial judge had decided there was no loss, rather on a similar basis as I had submitted here, that there was no evidence that the business had suffered any downturn because it had achieved viability, and the claim had not been put on the basis of loss of profitability or replacement costs of a manager and so on. But the Court of Appeal didn't like that, and Lord Justice Bean said at paragraph 5 that he had some sympathy for the judge because it was made more difficult by the absolutist submissions on behalf of the claimant and the almost equally absolutist submissions on behalf of the
When I said absolutist, I wasn't deliberately quoting from that. I might have been subliminally affected by it.
I have to plead guilty to the almost equally absolutist submissions because I acted for the defendant. But the point about the claimant's approach was that, again, as in this case, it was simply a projection of the profits of the business. And it was said, well, that is the starting point for your lost year's claim, regardless of any impact. Lord Justice Bean said this. Paragraph 32, the claimant has, by the time of the mesothelioma diagnosis, retired from work, then there will be no loss of future earnings, so there may be a claim for loss of pension. Suppose that Mr. Head had, before experiencing any symptoms, decided to cease all active involvement in EMSL, put his feet up and enjoy his retirement, while retaining his shareholding in the company. Then dropping down, If that is what Mr Head had done, with or without a title, then the loss of earnings claim would indeed be zero. That is not, of course, what happened. Far from it. Mr Head was not the honorary president of the company, or any sort of passenger. He was and would remain the driving force. So we have a rather similar situation to this one. And then, paragraph 33, the company paid Mr Head a very modest salary, the level of which the judge accepted was fixed for reasons of tax efficiency and did not reflect the value of his work. With respect, it seems to make no sense at all and be entirely contrary to Warden Newell's to say that this was the full extent of his earnings from work. All the rest of his income from EMSL at the time of his death was and would have continued to be income from capital rather than earnings. As Mr Justice Cavanagh did in the Rix case, I consider that at the time of Mr Head's death, all the income which he and his wife received from the company, save for a small deduction in respect of Mrs Head's work, was the product of his hard work and flair, not a return on a passive investment. 34, Mr Head was free to dispose of that income in whatever way he chose, by contrast, as Mr Steinberg rightly observed.
Well, do we need all this?
No, I think
short
I do.
of time. Well, that's important for you.
Yes.
Or important for you to meet, I'd say.
Well, it certainly. And then paragraph 35, he identifies a way of doing it, which is to note that until a certain age he would have continued to receive dividends, and then 3 lines from the end of the page, once he no longer worked full-time, his dividend income from EMSL, on the assumption made in this case of it remaining at a constant level, could properly be treated pro rata as income from investments rather than earnings from work. Now, what unfortunately, that was remitted, and unfortunately that gave rise to a dispute as to what the Court of Appeal meant. We had read it as meaning the income received, because he was receiving, page 346 of the bundle, income as set out, but 61% of the profits were ploughed back in and retained. Mr Justice Johnson, unfortunately, decided, for the defendant, decided that it did mean everything, including retained profits. And that's paragraph 45 of his judgment in the next tab, page 367. That is where the matter rests.
I expect you'd like us just to go down the corridor and ask Lord Justice Bean. And
Mr Justice Johnson was asked to refer it to Lord Justice Bean, and he said constitutionally that wasn't open to him. He had to decide for himself. It is a fact that we have filed notice of appeal, but no permission has been given or considered. But the point I'd make in relation to what Lord Justice Bean was saying was that setting aside the absolutist approach and putting a value on someone's day-to-day activity, it makes sense to look under basis 2 as to what a replacement manager might have cost. It might make sense to look at how the profits have been impacted on a broad brush basis. It makes sense also, we say, to look at the historic earnings, household income from the tax returns. Those are all ways of getting at this question, this factually, see what is the loss. But if Lord Justice Bean was rejecting the absolutist position adopted by the claimant there, then we would say it should be rejected in this case as well, particularly where this is a claim by a dependent, and therefore the question is, what has that dependent lost?
well done. Okay. Now we've been through it all. It's hard to see what he meant by the last sentence of para 33, except that in a case of this kind, and he had the facts of this case in front of him, you treat all the income from the assets of the company
Was all the income
as, well, as amounting to the dependency, subject to the standard netting off you have to do.
Yes, well, he says received, because the problem is that it was 31% of the profits that were being received, not 100%. And although Mr Justice Cavanagh's judgment was referred to, of course, there was no detailed argument as to what underlay it.
So I see, you say received you can live with, and all that, but you say Lord Justice Bean was wrong to equate that to the detail of what Mr Justice Cavanagh did in this case, because that was a case effectively where 100%.
Yes, he didn't have the details. And we do focus on paragraph 32, because what could Lord Justice Bean have meant, asked rhetorically, if he contemplates the claimant in that case having retired to live off his investments? He could only mean that the investments had a value. The company shares had a value. Of course, they had a lower value than if he had remained the driving force in the company. And so that's why we say, given the Lord Justice Bean rejecting the absolutist position of the claimant, and that observation in paragraph 32, he is referring, and no doubt thought that Mr Justice Cavanagh was referring effectively to income coming in. And we know from the tax returns that the income coming in to the family was very much less. Of course, it's right that there's no particular magic about the level of, you might have a very modest businessman who doesn't really have any interests outside the business, so he doesn't take much in the way of dividends. You might have a much more extravagant businessman who wants to spend time in the Mediterranean. But, and so I can see that one shouldn't be hung up too much on this question of retained or distributed dividends. But it's a way of saying that's what Mr Rix, as it were, thought he was worth, because he was taking this amount out, and we see it in their combined tax returns. I see that I've got very little time left for...
Well, let's just think about this realistically. It's not inherently unfair that the respondent will have less time because there's a certain amount of ground that won't have to be gone over.
Yes.
So I think we do need to hear you on grounds 2 and ground 3, but we need to hear you very briefly on those. If that means you going very slightly into the afternoon, we can live with that, but not by long. How long are you going to be?
Oh, very, very quick. They're pure
Are you going to them now? There's nothing more you need to say about ground 1.
I think that covers it.
Okay, well, let's see how we go on ground 2.
Ground 2, it's dealt with in paragraphs 69 to 87 of the judgment. You're hopefully familiar with the way in which, in personal injury cases, the court tries to get at the reality of what the loss is, and if an injured claimant who happened to operate through a partnership for tax efficiency reasons, but perhaps has a wife or husband who was not active, is injured and can't carry on, then the loss may be seen as entirely the injured claimant's loss. What we say is that it doesn't really work in relation to a Fatal Accidents Act claim, because one's looking at the dependent's loss. Of course, this is really only arises if we're wrong about ground 1. If the loss is done on this gross spec correctly done as the learned judge did it, then it makes a very significant difference to treat Mrs. Head's own shareholding income as if it was her husband's. The authorities, the only authority really I need to focus on is Kent and British Railways Board, because that's the foundation for this line of this approach. And what that is at tab 10. And it was a case where, by agreement with the Inland Revenue, that there had been a 60-40 split of the income, and the plaintiff claimed and got from the master, I think it was, 100% of the loss, and that was reduced by the Court of Appeal not to 40%, which had been agreed by the Revenue, but to 50% on the basis that was the reality. And it's Lord Sir John May at page 155 of the authorities bundle, top of the page, and if I can invite the court to read the top 2 paragraphs.
Yeah.
And to note the reference in the second paragraph, necessary carefully to analyse the nature and legal incidence of the relationship in plaintiff and her husband of the business. And note that section 24 of the Partnership Act said that the presumption of equality was subject to any agreement expressed or implied. In the paragraph after the next paragraph, the conclusion of Sir John May is that that presumption was not displaced. Because at the end of it he says, when one looks at the reality of the situation as it obtained between husband and wife, I doubt whether there was any sufficient agreement within the statute to alter the prima facie equality presumption. So that is, we respectfully say, has been misread in some cases as meaning that the reality of the situation gives the court some sort of broad discretion. Whereas what Sir John May was talking about was whether the evidence supported an implied agreement to set aside the 50% presumption, the equality presumption. And so, and in Ward and Newell's, which to save time, I won't take your lordship through it unless it's necessary. I quote parts in the skeleton. Again, this was applied without any suggestion that they were seeking, nor could they, to depart from Kent and British Railways Board to another partnership case where a different result was arrived at. But and there's reference to the reality of the situation, and that's because the reality of the situation would then allow one to see under the Partnership
Well,
Act.
that was because the partnership was terminable at will.
Partly because it's terminable at will. Yes, but that led to a conclusion that Section 24 allowed an implied agreement to the contrary.
Now, I see the time. I'm just wondering whether this isn't the sensible way forward. We will, over the adjournment, just look again, or I will certainly, maybe my lord and my lady are completely on top of it, at round 2 and what both you and Mr. Phillips say about it. If we have any questions, we will give them to you at 2 o'clock. Otherwise, you'll just have to wait and see. Maybe get a chance to say a bit more in reply. We will give you 10 minutes on round 3. Will that be enough?
I'm sure it is.
And then we will hear from Mr. Phillips. That ought to be enough for you, Mr. Phillips.
My lord, I hope so.
It should be, but for the reason I gave, that we've been some of the stuff. So some ground you won't have to go over again. So, very well, 2 o'clock.